Challenging non-priority decisions is actually easier than you realise. So in this video I'm going to pick apart Bedford Borough Council's template non-priority decision just to show how easy it is. Before we get into the nitty-gritty, it's important to say that if you've received a non-priority decision letter, the first thing you want to do is go and try and find a lawyer that has capacity to take on your case. But in the real world that's not too easy because there's not a lot of lawyers around. So the next best thing is going to be a homelessness professional who is able and willing to take on a local authority and get a decision overturned. But unfortunately that too is not very easy. Lots of homelessness professionals don't actually understand the law well enough to effectively challenge councils, and those that do can often be reluctant because they're often funded by the council. So unfortunately you're kind of on your own a lot of the time. That's why I'm doing these videos, trying to equip people to actually take on councils themselves. It can be done. You don't need to be a lawyer to win these kind of arguments. You need to know your case, which obviously you will do because you're the person who's involved, and you need to be willing just to look past the legal jargon that can seem very intimidating in these letters and actually just focus on the information that shows that you're in priority need. It's also important to say that if your letter you're getting is about medical priority rather than priority need, then it's likely your application for housing has not actually been identified as a homelessness application, and instead it's just been dealt with under what's called Part 6 of the Housing Act rather than Part 7. I've done videos about the difference, but ultimately if you're homeless in that situation where they're talking about medical priority, you want to go back to the council and just check that they've actually accepted the homeless application when they should have, and if they haven't, then trigger it. I've said lots of videos before, ask the council for help with housing, give them reason to believe you might be homeless, that triggers the homeless application. Anyway, back to the case in hand. So I'm just going to share my screen here, and here we have the template letter that Bedford Borough Council use. We actually requested this through Freedom of Information back in the last summer, so this letter was last updated in July 2022, and that's significant as we go through. But this is often what you're going to be confronted with when you see these non-priority decision letters. Right from the get-go you've got this really kind of high legal jargon which is used. So here for example it's saying homelessness application, notification under section 184 of the Housing Act 1996 Part 7 as amended. Now as a layperson that might not mean much to you, but in one sense it doesn't really need to. What's important here is whether they've considered your information properly in the course of this letter. Now as we scroll down we'll see this language being used here. So after careful consideration the council has determined that you are eligible for assistance, homeless or threatened with homelessness, and that you do not have a priority need. Now this is really crucial because if you don't have priority need then the council has a lesser duty to you within the Housing Act. They still have a duty to help, they still have a duty to give you advice and assistance, but they don't have a duty to put a roof over your head, and it's going to be much more difficult to get social housing if you are not in priority need. So that's why that's significant, and that's why in one sense this is such an important argument to make sure it's actually been considered properly within the council's notification. Now it goes on to say essentially by starting it gives you the categories or the criteria which make someone in priority need. So we've got pregnancy, dependent children in there. As you kind of scroll down you can pause it if you want to have a look at it in more detail, and then you've also got the characteristics that come with vulnerability, which I'm going to talk more about later, and the letter actually goes into more detail as we go through. So then concludes the first section by saying that given that none of the above apply to you, I must therefore conclude that the council does not have a duty to rehouse you. With regard to your housing problems, the council will continue to provide you with advice and assistance only. Now arguably this letter is likely to actually have its roots before the Homelessness Reduction Act came in, so in one sense I wouldn't actually say that's a particularly accurate sentence to put in there. So next you come to this paragraph which on first reading looks really legitimate, it looks really weighty, it's got lots of legal terminology in there, and as a layperson you can kind of give up and think, Struth, you know, what's the point of arguing with this housing officer? They clearly know what they're talking about. But if you actually look at it in any detail, what you'll realise is that this paragraph here is well over 4 years old. So it actually talks about the Homelessness Code of Guidance 2006. Now the Homelessness Code of Guidance was updated in 2018. So it looks to me like Bedford Borough Council has been using this template letter for 4 years, and no one's actually bothered to actually read it, or if they have read it they don't understand the significance of what it actually says. And this brings me on to a point that lots of housing officers will have no specific training in the sector, they don't have any qualifications, many of them simply learn on the job, and often they learn badly. You know, often they're trained by people who also don't really know much about it either. So often you're going to have to go further up the hierarchy to find a housing officer who has a good understanding of housing law, and that's probably the first thing I want to say, is that you're not having to win an argument against a really experienced lawyer, you're basically making an argument against someone who may well have been working in parking office 2 weeks ago and has just been drafted in and is writing these template letters. So don't be intimidated by the language that's used and the fact that it seems very, seems very technical. As I say, you can kind of just skim over this stuff, it's not really that important. The first section that probably is important here is this bit here. So in reaching the decision, the following additional information has been considered and taken account of. And what you'll have here is a list, usually maybe of a handful of different sources of information. The first one will usually be your representations, which simply means the information that you provided to the housing officer in the course of your emails or interview or whatever it was. And then often there'd often be here inquiries that are made to relevant professionals. So for example, if your argument is that you are in priority need because of a mental health issue, what you have here is usually just a GP patient summary, which is generally not worth the paper it's written on. Patient summaries are simply not detailed enough really to inform the housing officer of whether or not you're in priority needs. So if you are seeing organisations miss this, so for example, if you are being treated by the CMHT and the council has not made inquiries of the CMHT or has not included information from the CMHT in this decision, so when you're challenging this decision, one of the points you're going to make is that actually the council has not considered the correct information. And you'll see this as well with things like domestic abuse, where the council might have made inquiries of the police, but they haven't made inquiries of the MARAC or the IDVA service or another support service, where actually they will be best placed to provide this type of information. And as we go down a little bit further, the next kind of area that you want to challenge on is going to be the paragraph or the group of paragraphs in the decision which is around the Equality Act, the Public Sector Equality Duty. Now again, different councils will have different templates, although they'll often resemble each other, but there'll be a paragraph, there'll be a section within it which talks about the Public Sector Equality Duty, which is essentially the duty on any public bodies, which includes councils, to carefully consider disabilities of the people they're helping. And again, it can seem very technical. So you've got this situation here, they're quoting some case law, this HOTAC case, which is a really important one back in 2015, and a really good example of where this has gone wrong. So a few years ago I worked with a guy, he had PTSD and osteoarthritis in various joints. He was under the pain clinic in hospital because it was so bad, so he was prescribed Oromorph. And what the housing officer did was they had this template, and literally what they said was, I've carefully considered your health issues, which are PTSD and your osteoarthritis, and I have carefully concluded that you don't have a disability. And it was like, you can kind of see how bad these decisions are. What we actually did with that, if you're interested in raising these concerns on a wider level, is we literally quoted that paragraph and we sent it to the housing committee, and as a result of that, the whole housing team had to do really decent quality Equality Act training, so actually they knew what they were talking about when they were writing these decisions, because lots of housing officers have never had any training at all on the Equality Act, so they're simply not equipped to make these kind of decisions properly. And again, you've got this kind of section in red, which is the bit the housing officer is supposed to change. So here you see this template is basically showing the housing officer how to frame the argument that the person doesn't have a disability, and then it goes on to say that even if you do have a disability, that doesn't necessarily mean you're in priority need, which is technically true. I can't really think of anyone who's got a disability where they would not be significantly more vulnerable than an ordinary person would be if homeless, and that's essentially the test that the council should be working to here. So again, if you have a disability, just to make the point, if you have a disability and the council is not recognising it properly, again, this is going to be a really good, strong challenge to make to the review officer, to show that actually this housing officer has not actually dealt with your case properly or looked into it properly. And this whole thing about, the fact the template says I've carried out this exercise in substance with rigour and with an open mind, doesn't in any way mean that the actual housing officer has done so. Often this is kind of what the judges will call lip service, where housing officers, they'll say I've carefully considered your circumstances, when actually they haven't even looked at anything about you really. So they're just making these decisions in very quick succession without doing proper inquiries and proper consideration. Once it's gone past the disability section, we get onto the test of vulnerability, and what you've got here is essentially pretty much a whole page which is drawing from particularly HOTAC, the HOTAC case, where it's laying out what the theory is behind vulnerability. And it's not a terrible job, but if you're an advocate, I would highly recommend that you go and check out the full transcript of the HOTAC case, because there's a whole lot of stuff in there which this basically omits around things like the terminology. So where the case here talks about an ordinary person, In the full judgment, it talks about an ordinary, healthy and robust person, and ultimately that is our comparator. So what the housing officer is supposed to do is compare you to an ordinary, healthy and robust person who might theoretically become homeless, and they're essentially comparing the harm that you would come to compared to that hypothetical healthy and robust person. So it's not saying that, you know, no one suffers any harm. It actually makes the point that even if you're healthy and robust and you became homeless, it's still going to be very distressing. It's still going to cause some level of harm. But the question is there something pre-existing about you? It might be a health issue, it might be history in the forces, it might be institutionalisation in prison or something like that, which means that you are going to cope with the effects of homelessness basically not as well as a healthy and robust person would do, in a way that actually means you're going to come to harm. I'm being a bit clumsy with my terminology there. I've done videos specifically about vulnerability, and you'll see other bits on the channel which talks about it, but that's ultimately what this test is all about. And it goes on to quote another couple of cases here, so we can see Smith v Haringey as well, which kind of added to the definition. And essentially this is just laying out, this is supposed to lay out in layman's terms what the test is. I mean, I don't know too many lay people who'd immediately be able to understand it, but if you spend a bit of time, you can figure out some of it. And essentially just whenever you see these section numbers, just basically skip over them. They're not going to help you understand what's going on. Just basically read the words between those technical jargon bits. So having laid out that definition of vulnerability, they then come to medical circumstances, medical problems and circumstances, and this is likely going to be the bit which shows that you're in priority need. Incidentally, if you're in priority need because of one of the automatic characteristics, the council's going to struggle to really challenge that. They would potentially be able to challenge or cast doubt on the fact that you might be experiencing domestic abuse, and some housing officers really do lay into you. So they'll say things like, you know, you haven't got a police crime reference number, so therefore you're not in priority need, other nonsense like that. But it's likely that these non-priority decisions are going to be centred on whether you're vulnerable or not, because it's a much more kind of grey area. It's far less black and white. So here we've got essentially the same criteria that we saw before, and it goes through, so old age, and it then gets straight on to mental illness, handicap or physical disability. And you have to forgive the council with their wording there. Handicap is a word which is still used within the law. So here we can see some very common mistakes that housing officers make, and again, you can forgive the housing officers because the actual template itself is really pushing housing officers into making poor decisions. So if we start here, so again, you know, it basically talks about listing the illness conditions and talk about how you reach your non-priority decision. Some standard wording may include. So then it goes on to these, there's actually 5 different sentences here, all of which I'd say are actually very problematic. So the first one's probably the least problematic of the 5, but it's still some issues with it. So you have been diagnosed with depression and low mood. You are not prescribed any medication for this. Now, I've met plenty of people who have long-term mental health issues, but they decline to take medication because of bad side effects or whatever. And so in one sense, the idea that because you're not taking medication, you're not affected by any condition, that in itself is not going to be sound. You know, there may well be some truth in this sentence, but actually for some people, they genuinely have good reasons for not taking medication. Or you may even have people whose part of their mental health presentation is that they may be paranoid and therefore may not be taking medication. And in many cases like this, that's actually an indicator that they're more vulnerable, not less, and something that you need to yourself probably contact the treating professionals just to get that kind of opinion so that you can take it back to the council. The second sentence here, so you're being supported by your GP and are not involved with the community mental health team. Again, that's very poor reasoning. You know, councils have got into trouble with judges by using this kind of moving the goalpost technique. So in one sense, you know, they say, yeah, you know, you're being treated by your GP, but you're not being treated by the CMHT, therefore you can't be vulnerable. That's actually been shown to be an erroneous one. I remember a lady I worked with a few years ago now. I went in, so there's 2 people in succession. I went in on 1 week, and this lady, it was back before UC had come in Bedford, so she was on a job seekers allowance, and she had lots of issues. I won't go into too much detail, but the housing officer said, oh, you know, you're only on JSA, you're not on ESA, therefore you're not in priority need. And we challenged it, we got it overturned. She's still housed to this day as far as I know. The next week I went in with another lady, and she was on ESA, which is the kind of the long-term sick benefit, and the housing officer kind of tutted at her and said, you know, you're not on DLA, you're not on PIP, you know, you're only on ESA, therefore you can't be in priority need. So lots of housing officers, they have this kind of method of approaching priority needs, where they'll, essentially find out the situation about you, and then, kind of say, well, you're not at this next level, therefore you're not in priority need. And in the Paniotu case, I'm not sure if I'm saying that name right, that it said earlier up in the decision, the judge actually kind of made this point, because what housing reviews had done was they said, yes, you've got some significant health issues, but you don't have any overnight care needs, therefore you're not in priority needs. And as I say, the judge said that's not the correct way of looking at it. And again, this template is kind of pushing housing officers towards that incorrect approach. And then the next one, so I've considered your claim of mental illness. In applying the vulnerability test, I've looked at whether the condition you state is neurotic or psychotic and the level of treatment obtained. I note there is no evidence of current psychosis. And as far as I know, these particular sentences here probably date back to a long time ago. I remember seeing notes from a now medical training day that was done, I think probably 12 or 13 years ago, and in that they had these kind of indicators. So certain conditions would be more likely to be lead someone to be in priority needs, and other conditions less. And it specifically said, if you've got psychotic conditions, then psychotic symptoms, then you're more likely to be in priority need. If you're only neurotic, then you're less likely to be in priority needs. And that seems to have kind of found its way into these decision-making notifications. But again, just to make the point, just because you're not experiencing psychotic symptoms does not mean you're not in priority need. Plenty of people with just neurotic symptoms will still be in priority need. It's just they're kind of misdirecting the council officers' decision-making focus. The next one here, so I'm satisfied that you are not in receipt of any disability benefits that would lead me to believe that you need extra care for your medical conditions. And again, there are lots of people who don't receive PIP, not because they don't have a disability or they don't have those extra needs, but simply because the DWP has got a perverse decision-making system itself. I never forget, I went to with a guy to an assessment, a PIP assessment a little while back, and he had dementia. He could not remember his own name. He could not spell his name. He couldn't recall what it was. He remembered what his nickname was, but he couldn't remember his actual name. And he was assessed as being fit for work. So just because someone's not getting that PIP assessment or that PIP payment doesn't mean to say that they're not vulnerable. As I say, it might be that they haven't claimed PIP at all, or it might be they just had a perverse decision and they haven't challenged it yet. So that's that. Again, it's not, it's not in any way something which is going to be a defining factor of whether they're in priority need or not. And then finally, if ruthless, I'm satisfied that you can continue to obtain treatment for your physical and mental health condition and be able to access all services that currently support you. Again, logically, this is very poor kind of thought process here, or very poor logic. There are going to be lots of people who, just because they're homeless, it doesn't mean that they can't get to their GP, and that still doesn't mean that they're not in priority needs. Lots of people have health issues that are, they'll continue to present risk to them. There'll still be a risk of them deteriorating if they're homeless, and yet they're still able to access that treatment. It's just that the treatment is not 100% effective. So, it shouldn't surprise us to actually think that, many people who are able to access assistance still are going to be vulnerable as a result of their condition, how their particular condition affects them in their particular circumstances. So I'm hoping that this is helpful. By the way, interestingly, this is the sort of stuff we cover on the online training that I deliver. So if you're interested in that, by the way, if you are a professional or you're an advocate or something, check out the Eventbrite link in the comments. That can kind of give you the upcoming dates. But then we go through the remaining criteria of the vulnerability test. And again, I'm not going to go through them in any great detail. You can see them on the screen there. Again, you've kind of got these, bits in red that the housing officer is supposed to fill in. And again, they're just, this template is not in any way kind of helping housing officers really enter into the argument here. It's very simplistic. Essentially what they're kind of expected to write, or what they end up writing is, you've been in the armed forces, but I've carefully concluded that you're not in priority need, and that's sort of the end of it. And again, that's really open to any kind of challenge, really. The final one I will kind of pick up on here is the any other special reason. It's the kind of catch-all that covers vulnerability in situations which were not envisaged within the Housing Act itself. And so, this could be all sorts of things. It could be a combination of factors. The Code of Guidance is clear. Things like common mental health issues or substance misuse issues, or things like not managing a tenancy before or having a long history of rough sleeping would all be relevant here. I think it's 8.40 of the Code of Guidance if you want to have a look at that. But again, it's not in any way helping the housing officer identify whether the person's vulnerable as a result of, for example, alcohol or substance misuse issues. The case law is clear that it's possible to be in priority need solely because you have a substance misuse issue and you are trying to deal with it, and being homeless would potentially mean that you're at risk of relapse or whatever. That has been long established as being a potential source of vulnerability. But this template is in no way helping housing officers actually consider those types of cases and how they would consider this sort of information. So again, it's likely that if you're affected by these kind of criteria, that you can make a challenge simply by giving the council more information. We'll go through again there's kind of a whole pithy paragraph here, and again, you know, this paragraph here, for example, so I have therefore looked into all your medical problems and circumstances together as a whole. Having done so, I'm satisfied there is nothing that differentiates you from ordinary people who are homeless for the reasons given above. Now again, that's a very clumsy sentence for a legal notification like this, because the test is not ordinary people who are homeless, it's ordinary people, hypothetical ordinary people who may become homeless. And so again, you're comparing your situation with that hypothetical healthy and robust person who would become homeless. It's not that, you know, as I say, it's not people who already are homeless. And so, and again, you know, this kind of idea of nothing differentiates you between, you know, yourself and a healthy ordinary person. I remember a guy a few years ago, again now, I met him, he'd just come out of an inpatient psychiatric unit, and he had got like a laceration all the way down his forearm, like the inside of his arm or whatever, and it was still very clearly healing. You know, this must have been a very deep laceration. I understand it was very life-threatening, and it severed the artery. And this was the language that was used in the non-priority decision. You know, I've carefully considered your situation, and in the face of the information that we got from the consultant psychiatrist on the ward, they simply said, you know, I'm satisfied. There's nothing that differentiates you from a normal, healthy, and robust person. And again, you know, this kind of perverse decision is not uncommon. And as with that one, it was literally just a case of spelling out to the reviewing officer, you know, a healthy and robust person has not just been in an inpatient unit for attempting to kill themselves. So therefore, the original decision is not even close to being right. Anyway, so that's kind of the end of that section. You've then got this section here, which is really kind of relating to the personalised housing plan, which I'm not going to talk about too much detail here, so I'm not going to say too much. There's a little bit here about, you know, kind of saying what the person's eligible for in terms of the local housing allowance. And then it kind of goes on to some pretty pithy statements about what they should do. You know, you should go look for private rented accommodations if most people haven't already tried that, and you know, as if it's like affordable and there's lots of options around. But what it does say here is actually quite useful. So again, it makes the point here that there are various budgets within the council which can be used to help you get rent deposits, rent in advance, potentially some money to pay off old arrears or whatever, if it's going to help. So there are some budgets which are available if you were to go and find a private landlord who's happy to work with the council, which would enable the council to help you into accommodation. So as I say, it's not all bad in this. You've then got a section here which essentially makes the point that if you are already in temporary accommodation, so the council had reason to believe that you might be in priority need, so they put you in temporary accommodation, they've now satisfied that you are not in priority need, and therefore you need to vacate the temporary accommodation. Generally in Bedford it's within 7 days, but it can be less, I think, in certain areas. And then that leads to the final paragraph here, which has to be in there, which is basically your right to request a review. It's called Section 202 of the Housing Act, if you want to know. Not that it helps you that much. But this paragraph here is actually incorrect. So it says any such request must be received in writing within 21 days of the date of this letter. And actually that's completely false. You've got 21 days on the date of receiving the letter. So I've worked in various cases where the date of the letter might be like the 1st of May, and actually the internal postage system at the council shows that it was not stamped until the 15th of May. You know, that's 2 weeks later basically, and yet the council are going to try and say that, you know, that person had been notified on the 1st of May. It's nonsense. It's the date that you've been notified, not the date of the letter. So I think that's, as I say, that's a whistle-stop tour of these decisions. I'm probably going to do some more ones about the other templates we've got, because there's some really interesting bits and pieces. But I'm hoping, if nothing else, you can see that even in the template itself there are mistaken, incorrect statements made, and the template does not help the officer actually consider the proper test. In which case, you know, all you need to do a lot of the time is just to provide the right information, which may involve also going back to your GP and saying, hey, can you provide more information for me to take to the council in order to challenge them? Again, I've done videos about what you need to ask them. There's essentially 3 questions you need to ask your doctor, which basically state whether you're going to be vulnerable, or, you know, or would enable the housing officer to make an informed decision about whether you're vulnerable or not. So that's one of the things you can do, but you can challenge those, you know, anything around here in terms of disability, anything in terms of the inquiries that have been made, they are all up for grabs. And ultimately, you know, as I say, you are the person who knows you best. Providing as much information as possible in that review request is going to likely mean that you get a fairer hearing, and you're more likely to have a fair result. And if you find this stuff helpful, do subscribe to the channel. It just means you'll get notified when new videos go up. And also, crucially, if you know people who might benefit from this information, feel very free to to share it with them. Hopefully this kind of stuff will get out there. And as I say, whilst we don't have enough solicitors to go around, it really is going to be down to the people who are actually homeless to fight their case, which is not the way it should be, but it's the reality we've got at the moment. Hopefully this information will actually equip people to be more effective in challenging these stupid decisions.